So, my lady, I'm going to turn to what we say are the applicable legal principles, and these are set out in our written case. It's MS 117, paragraphs 6 to 19 of our written case. And we've identified, first of all, the great importance attached by the common law to the right of personal liberty, described as one of the three absolute rights of individuals by Blackstone, protected by the common law. And we've made the point about the jealous protection that the common law gives to the right of liberty through various mechanisms, of course most famously including the writ of habeas corpus. But the tort of false imprisonment is one of those mechanisms. And in our submission, that context and history of the importance attached to the right to liberty is relevant to the proper definition of imprisonment for the purposes of establishing the tort of false imprisonment, because the definition that's adopted should be one which enables the practical and effective enjoyment of the right to liberty. We then, in our case at paragraph 11, set out the definitions of imprisonment that are adopted by the leading texts on tort. I don't propose to go through those now. They are all in the authorities bundle. Just for the court's reference, it's tabs 73, 78, 79, and 80. The definitions of imprisonment that are adopted by the leading textbooks are each somewhat differently worded, but in my submission, they all express the same basic concept. And I would like now to encapsulate what we say are the ingredients of imprisonment in a number of propositions, which I'm then going to substantiate by reference to the case law. So the first proposition is that imprisonment consists of the imposition of restraint on a person's liberty so that they are compelled at the will of a third party to stay within a defined boundary. The second proposition is that the restraint on the person's liberty must be complete in the sense that they are required to stay within a defined area. There is no imprisonment if a person's ability to move is blocked in one direction or by one route or means, but they remain free to depart in a different direction or by a different route, even if that's not the route that they would have chosen. The third proposition is that a restraint of this nature will constitute imprisonment, no matter how short its duration. Even a few seconds is sufficient. The fourth proposition is that the restraint on the individual's liberty must be immediate and not conditional. In other words, there is no imprisonment if a person is free to leave a place, but if they sought to do so, they would at that point be detained. Now that is the proposition for which we say that the case of Bournewood, ex parte LL, is authority. I'm going to return to that case a little later. And we say that it also explains some of the cases like Arrowsmith and Mesurier. But there are some important qualifications that I'm going to come back to, but that's the basic proposition. The fifth proposition.
How many do you have, just in case we run out of? That's turning over
I'm afraid
several
there are
pages.
8, my lord.
I was going to say turning over several pages.
Yes.
Ominous.
No, well, this is really the heart of our case, and
Well, if we're on number 5, 8 isn't too daunting.
so this is number 5.
Yeah.
The notion of complete restraint of liberty does not mean that there must be some physical barrier, such as a lock or a guard, to prevent the person from leaving. Now, that was a proposition that was advanced by Mr. Tam in his written case, but which doesn't appear to be maintained by him. But just to make it clear, we say that's not correct. Nor does it mean that it must be physically impossible for the person to leave. That is not what complete restraint means. And we say that any suggestion that an ability to leave means that there's no imprisonment is wrong in law. Now, dealing with those two propositions, the first suggestion that there must be a physical barrier, we say that's wrong because imprisonment will also occur if a person is compelled to stay in a place by intimidation or by fear of the consequences if they leave, or if a person submits to the apparent authority of a legal process. I say apparent authority because, of course, where there's false imprisonment, that authority must not have actually existed. So imprisonment also exists if a person is compelled by fear or by fear of the consequences, intimidation, or by submission to an apparent legal process. And to give some examples of this, an obvious example is the idea of coercive control in the context of modern slavery or in the context of domestic abuse. You could have a situation where a defendant threatens a victim with dire consequences if they leave a place where they're being held. You might threaten simply to harm the victim, but you could make different kinds of threats. If, for example, you had a woman who had been a victim of sexual trafficking from Romania, there could be a threat to harm her children in Romania if she leaves the house. The threat doesn't have to be to put her back in the house. It can be any kind of threat which is sufficient to intimidate her so that she remains in the house. In that situation, the defendant may go out and leave the house unlocked and unguarded, but the victim may be too afraid to leave. And that would be imprisonment for the purposes of the tort. They're confined against their will because of the threat. In that situation, you could not say that the victim, as Mr. Tam puts it, is capable of leaving, but simply choosing to stay. Now, of course, that's a very obvious example, but coercive control may be exercised over individuals by means that are far more subtle than that kind of overt threat. One example is what's commonly known as gaslighting. So there are all sorts of factual situations where, in fact, a person might be unable to leave, or, and this is important, reasonably unable to leave, without there being a guard or a lock. So that's the first case, which is intimidation or threat. We say that that principle also applies if a person is compelled to stay in a place by a threat of punishment if they leave, including arrest and criminal prosecution. It also includes a situation where a person is compelled to stay in a place by a defendant who purports to be exercising a legal power to order them to stay on pain of punishment. And that, of course, is classically what happens in the execution of a warrant for arrest, whereas the cases say there's no need for the sheriff's officer or the bailiff to lay hands on the individual. It's enough to say, I've got a warrant, and the person then goes with the bailiff because they think they have no choice. It's the implicit threat of punishment if they don't comply with the legal process that means that they're being coerced. So submission...
What about the situation where
Yes.
someone is insensitive to the sanction?
Yes.
Where they say, well, I don't care
Yes.
what is said here, I'm just going to go about my business.
My Lord, I'm going to deal with, this is obviously critically important, I'm going to deal with it in a little more detail, but in summary, my submission is as follows. Where I'm going to come to is that the right test is not a physical inability to escape or the complete domination of someone's will that they're unable to move or speak. The question is whether there is any reasonable means of the person leaving the place where they're confined. And there are circumstances in which it will not be reasonable for the person to do that. One obvious example is if they've been threatened with physical violence. And another example would be if the only way that they could leave the place is by risking criminal prosecution. It is not reasonable to say you should go because the door's not locked, and the fact that you're risking criminal prosecution and a 6-month sentence doesn't mean that you shouldn't go, because that's an unreasonable basis on which to say someone should escape. Now, and the same goes if they've been arrested under a warrant. But, so you've got two situations there. If the person is handed the warrant and says, oh, sod that, and runs away, then they haven't been falsely imprisoned for the simple reason that they escaped immediately and were never imprisoned. But if they went with the constable for half an hour, and before they got to the station said, hang on a minute, I don't think this warrant is valid, or I don't care whether it's valid or not, and at that point legged it, then they would have been imprisoned up to the point at which they left. The fact that they then escaped from imprisonment wouldn't mean that they previously were not imprisoned.
Yes, well, I can see that, but let's just take an extreme example. That someone was served with a restraint order and conceives in her or his mind, well, I'm not going to pay any attention to this.
Yes.
And I'll just go out whenever it pleases me.
Yes.
I'll stay in purported, or not even purported, but in apparent compliance with the order when it suits me. Is that person falsely imprisoned?
If the restraint order has no impact on them whatsoever and doesn't affect their conduct at all, then you might have a situation where you say there's no imprisonment.
Yeah.
But I'm going to come back to that,
Right.
that question.
Okay.
So where I got to is that if you order somebody to go with you or stay in a place under threat of criminal prosecution or punishment, that is imprisonment. Importantly, the threat doesn't have to be a threat to return the person to the place of confinement. One of the submissions that Mr. Tam made, and one of the ways in which he seeks to distinguish this situation from an open prison, is to say, well, the sanction, which could be arrest, prosecution, and potentially imprisonment in a prison, is not returning you to the same house. We say that's irrelevant. Doesn't matter. The sanction could be, I'm threatening to harm your child in Romania. What matters is that it's unreasonable in that situation to expect the person to leave. Now, the second requirement that the Secretary of State contends for is that it must be physically impossible for the victim to leave the place of confinement. That's when he talks about total or complete restraint. We say that's a misreading of the authorities and it's wrong. That the proper test is that a restraint of liberty will constitute imprisonment if a person is only able to leave a defined area by means which are unreasonable or by an unreasonable route. So the question is not a subjective one of how robust is their will. It's an objective one, are the means unreasonable? And there are various situations in which it will be unreasonable for a person to be expected to escape from confinement. One is if they can only escape by taking a risk of personal harm. So, for example, if a person is locked up in a room on the first floor, but the window is unlocked, the defendant couldn't argue that they were not confined because they could have jumped out of the window, if jumping out of the window would have risked harm to them. So that's one situation. Another situation where it will be unreasonable for the person to leave will be if they can only leave by defying a reasonably credible threat. And that includes a threat of harm to them, a threat of harm to a third party, or a threat of harm to property. And it also includes a threat of punishment. Where a defendant has made a reasonably credible threat of that nature, in order to confine a person to a particular place, he cannot be heard to say that they were not imprisoned because they should have been more robust and should have defied the threat. Now, I've said reasonably credible threat because there are obviously limits to this. If a toddler says to you, stay and play with me or I'll cut your legs off, that's probably not false imprisonment. Another situation in which it's unreasonable for the person to leave is if they can only leave by taking a risk of criminal prosecution, by a criminally unlawful act. Now, Mr. Tem disputes this, and he does so, of course, by reference to the 1699 decision of Chief Justice Holt, which refers to a situation where one door is locked, another door is open, and it would be a trespass to go out through the other door. We say that's a million miles away from a situation where a person can only leave by taking a risk of committing a crime, with the consequences attendant upon that. A technical trespass is not the same thing as a crime. And it's not reasonable for the state to say to a person, you must stay in this flat. If you leave, you will be liable to prosecution and fining and imprisonment, and then to say, oh, well, I wasn't confining you to the flat. Now then, an important proposition, where only unreasonable means are available for a person to leave, such as jumping out of the window or risking prosecution, and a person takes the unreasonable means and does leave, it doesn't follow from the fact that they did so that they were never imprisoned. So if, for example, a person is in a prison camp, a prisoner of war camp, but they're not overborne, and they make a wooden vaulting horse and dig a tunnel underneath it and store the earth in their trousers and eventually escape through the tunnel, it doesn't follow from that they were never imprisoned.
That example had been occurring to me in the course of argument.
Well, yes, my lady. And their will was never overborne, and it was physically possible for them to escape. But it was only physically possible for them to escape by unreasonable means, and that's the reason why they were imprisoned. Of course, they're no longer imprisoned after they've gone. And that's the same situation as the man who has the warrant from the constable, goes with the constable, and then after half an hour decides to leg it. The same is true of Rapunzel, of course. Rapunzel did escape from the tower by cutting her hair off, attaching it to a hook, and climbing down it. It doesn't follow from that she was never imprisoned in the tower. So similarly, if a credible threat of criminal prosecution and punishment is made to a person if they leave a flat, and they take the risk of that prosecution because of a powerful need to attend the family proceedings, which determine whether they'll have access to their children or to engage in religious observance, it doesn't follow from the fact that they took the unreasonable risk that they were not imprisoned in the first place. Now, there's a particular authority that bears on this question of reasonableness, which is a case the court hasn't yet seen called McFadzean, I'm going to come to in a little while. And that, we say, is the best analysis of this issue. So those are the key propositions that we say apply. And so that the test here is not about the particular robustness of the individual and how strong their individual will is. It's whether or not they are confined by the threat of coercive force to a defined bound and can only leave by unreasonable means or taking an unreasonable risk. Now then, coming to the authorities, Bird and Jones at tab 3, we say is the first in time of the cases that contains any general legal principles that can be discerned. The earlier cases are really simply assertions of whether there is or is not imprisonment on particular facts, and it's quite difficult to see anything approaching what we would identify as a legal analysis. But Bird and Jones is the first case that attempts to analyse what constitutes imprisonment. And the issue, it's tab 3, MS 487. The issue in Bird and Jones, and this is important to bear in mind, is whether there was imprisonment when Hammersmith Bridge had been closed and the plaintiff was not permitted to cross Hammersmith Bridge, but was perfectly free to go back the way he'd come. There was no issue in this case about reasonable or unreasonable escape routes. It was all about whether it was sufficient for his liberty to be constrained in one direction. And since this case is the origin of the references to complete restraint or total restraint, and in my submission, that's what it's talking about. It's talking about restraint in every direction as opposed to a partial restraint in only one direction, because that's the issue that was before the court. And we see that from the head note. Plaintiff attempting to pass in a particular direction was obstructed by defendant, who prevented him from going to any direction but one, not being that in which he'd endeavoured to pass, held not imprisonment. It's all about the direction. And if we go to Mr. Justice Coleridge at page 488, just under the number 744, he says, in my opinion, there was no imprisonment. To call it so appears to me to confound partial obstruction and disturbance with total obstruction and detention. A prison may have its boundary large or narrow, visible and tangible, although real, still in the conception only. Note those words, still in the conception only. The boundary doesn't have to be physical. It may itself be movable or fixed, but a boundary it must have, and that boundary the person imprisoned must be prevented from passing. He must be prevented from leaving that place within the ambit of which the party imprisoning would confine him, except by prison breach. So the key point that Mr. Justice Coleridge is making is it's not imprisonment to block someone going one way. There has to be a boundary all the way around. And you will note that he says, except by prison breach, but he doesn't seek to explore what prison breach is and how prison breach is to be distinguished from simply having a free exit route. And the reason he doesn't do that is because it doesn't arise on the case before him. He says, some confusion seems to me arise from confounding imprisonment of the body with mere loss of freedom. It's one part of the definition of freedom to be able to go whithersoever one pleases, but imprisonment is something more than the mere loss of this power. It includes the notion of restraint within some limits defined by a will or power exterior to our own, and we would respectfully adopt that basic definition. And then Mr. Justice Williams, again, is addressing the question of direction. As you can see in the middle of page MS 489, he wished to go in a particular direction and was prevented, but at the same time, another course was open to him. And he then, lower down that page, cites from Lord Coke in the Second Institute the example of the bailiff who says, you're my prisoner, but doesn't touch the prisoner, and the prisoner goes along because he feels he has no option. And that's where he talks about the entire restraint upon the will, which I apprehend constitutes the imprisonment. But what he's talking about is the person going with the constable because otherwise there is a threat of retaliation. What he says is, in such cases, though little may be said, much is meant and perfectly understood. It's the implicit threat of the warrant. And then Mr. Justice Patterson, at the bottom of 490, I've no doubt that in general, if one man compels another to stay in any given place against his will, he imprisons that other just as much as if he locked him up in a room. It's not necessary in order to institute imprisonment that a man's person should be touched. And then he says, I cannot bring my mind to the conclusion if one man merely obstructs the passage of another in a particular direction, whether by threat of personal violence or otherwise, leaving him at liberty to stay where he is or to go in any other direction if he pleases, he can be said thereby to imprison him. And it's in that context that he says, imprisonment is a total restraint of the liberty of the person for however short a time, and not a partial obstruction of his will, whatever inconvenience it may bring on him. The total restraint that's being talked about is a total restraint in the sense of restraint in every direction, not a restraint so complete that it makes it impossible for the person to escape. Because if that were the test, there would never be any case of imprisonment. Even confinement in Belmarsh, you could say it's not completely impossible for a person to escape. And then Lord Denman dissented, and if we go to page 492, he says, just before the number 755, he's towards the top of the page, as long as I'm prevented from doing what I have a right to do, of what importance is it that I'm permitted to do something else? So here he is addressing the question of one direction. And he says, how does the imposition of an unlawful condition show I'm not restrained? If I'm locked in a room, am I not imprisoned because I might effect my escape through a window, or because I might find an exit dangerous or inconvenient to myself, as by wading through water, or by taking a route so circuitous that my necessary affairs would suffer by delay? Now, in my submission, Lord Denman there is identifying a difficulty that arises from the over-literal reading of the reasoning of the majority, which is precisely the trap into which Mr. Tam has fallen. Because some of the points made there by Lord Denman, with great respect, are not correct, but one of the points he makes is, would you say, I'm not imprisoned if I can only escape by dangerous means? And the answer is, of course you're imprisoned in that situation. And what he is reacting to is the suggestion that a total restraint of liberty means there must be no conceivable escape route at all. And we're saying that he's right, that if the only way you can escape is by a means that's dangerous or that exposes you to criminal liability, then you are imprisoned.
The point is that doesn't reflect the facts of that case. It was perfectly
Absolutely.
feasible to
precisely,
take
my
it
Lord. And in my submission, that's exactly why you don't find the kind of analysis of reasonableness that we are considering today. Because in that case, the plaintiff was completely free to go back in the other direction without any constraint at all. So the issue of whether that was an unreasonable means of escape or involved him in any danger just didn't arise. His argument was that blocking his passage in one direction was of itself sufficient to amount to imprisonment. And when they talk about a total restraint, they are rejecting that submission. They don't mean total in the sense that it must be impossible for the person to leave. Now, the next case that I want to go to is Meering, which is at tab 6. This is the young aviation engineer induced to stay in a waiting room. And on the facts, he didn't feel he was under any constraint. But nevertheless, the finding was that he was constrained and he was imprisoned, even though he didn't realise he was imprisoned. And Lord Justice Atkin, this is at 557, the second column, addresses the definition of imprisonment. He says, this is the penultimate paragraph on that page in the second column, I do not think it's necessary at this stage, and with the time at our disposal, to go through the authorities dealing with the question of imprisonment. I'm disposed to think the definition of imprisonment read by my brother Duke from Terme de la Ley is an adequate and sufficient statement of what's meant by that expression. And he's referring there to a definition which the court will find at page 555 at the top of the second column. Imprisonment is no other thing but the restraint of a man's liberty, whether it be in the open field or in the stocks or in the cage or in the streets or in a man's own house, as well as in the common jail. And in all the places the party so restrained is said to be a prisoner, as long as he hath not his liberty freely to go at all times to all places whither he will, without bail or main prize or other reasons. And so Lord Justice Atkin identifies that as the definition, but then says there must be added, this is back to 557, restraint within a particular place. And he does that by reference to Bird and Jones. And he then says at the bottom of the page, a person could be imprisoned without his knowing it. And he then discusses that point. And then at 558, first column in the middle of the page, it is true that in all cases of imprisonment, so far as the law of civil liability is concerned, stone walls do not a prison make, in the sense that they are not the only form of imprisonment, but any restraint within defined bounds, which is a restraint in fact, may be an imprisonment. There's then the Syed Yusuf ud-Din case on which my learned friend relies, which is at tab 14. In our submission, that doesn't advance his case at all. Again, the issue in that case is the stark question of whether a person is imprisoned when they've been released on bail. And it's not surprising that the Privy Council decided that they were not imprisoned when they were released on bail. And at 718, all that is done is that the Privy Council applies Bird and Jones. It adds nothing to the analysis of the case law. The Robinson case at tab 12, this is the case of the man who didn't want to pay a penny to leave the wharf, is simply a factual illustration of the point in Bird and Jones that preventing a person from leaving a place in one direction is not sufficient to amount to imprisonment. Because Mr. Robinson had two ways to leave the wharf. One, he could leave on the ferry that he'd already paid for, and two, he could leave through the turnstile if he paid a penny, so he could leave on the contracted terms. And as the court pointed out in dialogue with Mr. Tam, a large part of the reasoning of this case is that he'd contracted to enter the wharf on those terms, and there was nothing to prevent the owner of the private premises from saying that in order to leave, he had to pay a penny. And interestingly, if you go to the bottom of page 656, tab 12, it said this: when he desired to do so, i.e. desired to leave, the defendants were entitled to impose a reasonable condition before allowing him to pass through their turnstile from a place to which he'd gone of his own free will. The payment of a penny was a quite fair condition, and if he did not choose to comply with it, the defendants were not bound to let him through. He could proceed on the journey he'd contracted for. Now, in my submission, there are 2 points that you can see there. There are 2 reasons why this isn't imprisonment in that paragraph. One is that he could continue on the journey he'd contracted for. He could go on the ferry. But 2, the condition that was being imposed for him to leave the wharf was a reasonable condition because it was payment of a penny. Now imagine a factual situation in which he paid a penny to enter the wharf, but was then told that the ferry was cancelled until the next day because of rough seas, and that he could only leave the wharf if he agreed to pay £100. Now, in my submission, in that case, there would be false imprisonment because his alternative route of leaving on the ferry would not be open to him, and his only means of leaving would be unreasonable, the payment of an unreasonable sum.
That might even be true if it's still just a penny to get out, because he paid the penny to go in to
Yes,
get the
and
ferry,
get the ferry.
cancelled the ferry. Is it then reasonable to charge him to leave when...
Your Lordship's right. Your Lordship's right. Because in this case, although there was a notice saying if you could only leave by paying a penny, it wasn't clear whether he'd seen that before he entered. Now, if he'd entered in the knowledge that those were the conditions, that might be one thing. But if he hadn't realised that, then your Lordship's absolutely right. So then we come to the Bournemouth ex parte L case at tab 11, the severely autistic patient who was admitted to hospital not under compulsion, was compliant, but where it was likely, to put the matter at its lowest, that had he sought to leave, an order would have been sought detaining him in the hospital.
And why was he compliant?
Well, my lady, indeed, because it would appear that he was not in a state...
He was heavily sedated.
Yes, exactly. Now, my lady, this case represents the law as it is at the moment. 2 submissions to make about it. First, it has no bearing on this case because its ratio is simply that where there is not a confinement at a material time, the fact that there might be a confinement if a person sought to leave in the future is not of itself sufficient to amount to imprisonment. That's the ratio of the case, as we shall see in a moment. And that's not the situation in this case. Our whole case is that the order itself was imprisonment.
Well, you could also argue that the ratio of the case was that the defence of necessity applied in any event.
Well, my lady, one of the...
That's the bottom line.
With great respect to Lord Gough, there is some difficulty in his analysis because the analysis of justification and the analysis of whether there is imprisonment are very closely bound up together. I'm going to come to it in a minute. But, so that's the first submission that we make. It makes no difference to the outcome of this case. The second submission that I do make is although it represents the law at the moment, in my submission it might well be decided differently if a case with similar facts were to come before the Supreme Court today. And I say that for a number of reasons. The first is, of course, that when it went to Strasbourg, the Strasbourg court found that there was a deprivation of liberty contrary to Article 5. Now, my learned friend is seeking to persuade the court to reduce the protection of the common law to what he says is the lower standard of protection under Article 5. That is, of course, heretical. But what is not heretical is that there are circumstances in which courts will extend the ambit of a common law right so that it provides equivalent protection to a right provided under the Convention.
Or
So-
even further,
Absolutely.
even going beyond it.
Absolutely, my lord. But just on LL, it's not impossible that if the same facts were to come before the Supreme Court now, it might be decided differently. And the first reason that I give is because of the subsequent development in Strasbourg. The second reason is one that I was just canvassing with my lady, that with great respect to Lord Gough, this is a problematic judgment. There was a unanimous decision of what I hesitate to call a very strong Court of Appeal.
Well, it was the Lord Chief Justice,
It
wasn't
was
it?
indeed.
Yeah.
My lady, and also Lord Phillips, who of course was subsequently the president of this court. It then came before the House of Lords, where there was a 3-2 split, a very strong dissent by Lord Steyne, and another from Lord Nolan, and where there was only one speech for the majority, which is the speech of Lord Gough. And with the absolute greatest respect to Lord Gough, it is not always easy to understand exactly what the rationale is. If we can just look at the material part of his reasoning, we're at MS 640. And as your ladyship, it starts at the letter F, and as your ladyship rightly observes, he starts by talking about necessity. And of course, whether it's necessary to confine somebody or not is not relevant to the question whether there's imprisonment. It's relevant to the question whether there is a lawful justification if there has been imprisonment. But he starts there. Then over the page at 641, he says there were times during the episode when it might be said that L was detained, in the sense that in the absence of justification, the tort would have been committed, and he refers to the ambulance. Then he says that was justified by necessity. And he says, I cannot see that Dr. Manjubashini's statements to the effect that she would, if necessary, have taken steps compulsorily to detain L under the Act of 83 have any impact on the above conclusions. And she says they must always have that possibility in mind. So he didn't accept that detention was inevitable if the claimant had attempted to leave. He then refers again to necessity. And then in one paragraph, he says the readmission of L to hospital as an informal patient could not, in my opinion, constitute the tort of false imprisonment. His readmission as such did not constitute a deprivation of his liberty. So this is a bare statement that voluntary admission to hospital is not deprivation of liberty. Then the point that he's not locked up, and the fact that she might thereafter take steps to detain him did not give rise to detention, in fact, at any earlier date. And that, I submit, is the widest that this ratio can be said to extend. And then, again, he deals with justification. So in my submission, the reasoning here is, with great respect, extremely thin. And it might well be decided differently in future. But that's a very interesting topic, but it's not a topic that we need to detain ourselves with in this case. Now that then brings me to a case we say is of central importance to this case, and it's the decision of the Victoria Court of Appeal in a case called McFadzean in 2007. And this is in Authorities Bundle 4, tab 57. And in my submission, this is the best and most complete analysis of what is meant by complete or total restraint of liberty and correctly identifies and explores the question of whether there is a sufficient restraint of liberty where a person's only means of egress from the area where they're confined are unreasonable.
Ms. Rhodes, could we have the MS number?
Yes, my lord, it's MS 1866. So the facts here were that there was a conflict between anti-logging activists and loggers. And various protests were taking place, and eventually the loggers blockaded the anti-logging activists in a particular area and refused to let them leave. And on the facts, the blockade extended a certain distance into the bush on either sides of the road. And the question was whether that blockade amounted to the false imprisonment of the anti-logging activists. And there were two reasons why it had been held by the court below that there was no false imprisonment, or no imprisonment. The first was that there was a reasonable route of egress open to the protesters because they could have asked the police to assist them to pass through the blockade. That's what's referred to in this judgment as the police gate argument. And the second argument was that there was another reasonable route of egress open to them through the bush route. And the Court of Appeal held that the police gate, in principle, was not a reasonable escape route. Because whenever a person's unlawfully imprisoned, you could say, well, they can ask the police to rescue them, but that does not constitute a reasonable route of escape. But they found on the facts of this case that escape through the bush was reasonable. Considering the kinds of animals that live in the Australian bush, I find this an unreasonable decision, but it's a question of fact that we might not.
Speaking from personal
Your
experience,
ladyship's penchant for spiders means your ladyship no doubt no difficulty escaping through the bush.
The Australian bush is slightly less dangerous than the African bush on the whole.
I don't know about that, my lady. The koalas can give you a nasty nip. So
Miss Rose speaks from personal experience, I think.
no, well, I declined to go to Australia on the grounds of its dangerousness. Those are the facts, and if we come to the relevant legal analysis, it's a judgment of the court, and the relevant part starts at page 1876, where the court says, helpfully, at paragraph 31, we start with basic principles. And we say the conduct with which the law of false imprisonment is concerned must be of a coercive character and amount to a total restraint. So there you see the test they're applying is the familiar test that we've seen derived originally from Bird and Jones. Accordingly, the question whether a defendant's conduct has influenced a plaintiff's action will not necessarily determine whether the plaintiff's been detained against his or her will. In some circumstances, false imprisonment may be made out, even though the conduct of the defendant has not had any influence on the plaintiff's course of action. Now, that's relevant to the question your lordship asked me, my Lord Kerr asked me earlier. What if the person doesn't care about the restraining order? It could still be a imprisonment. Neither is the converse always the case. The fact that the defendant's conduct may have influenced the plaintiff will not always lead to the conclusion that there has been an involuntary submission by the plaintiff to the defendant's restraint. They then cite Blackstone's commentaries and Street's Foundations of Legal Liability at paragraph 34, and the court will see it says, it's long been settled, actual physical constraint or physical contact not necessary to make an imprisonment, coercion of any kind, as where the person in imprisonment yields without resistance to superior force or to authority is enough. But some form of coercion is essential. They then discuss a number of the authorities. And if we go to paragraph 41, page 1880, be all that as it may, it remains the case that the essence of the action of false imprisonment is the compelling of a person to stay at a particular place against his or her will. Accordingly, where a plaintiff has full knowledge and comprehension of the defendant's coercive conduct, the action depends on proof that were it not for the defendant's conduct, the plaintiff would not have submitted to the restraint. It must be shown that but for the defendant's conduct, the plaintiff would not have yielded to the total restraint. The plaintiff's determination to remain was a coercive consequence of the defendant's acts. Secondly, as the judge observed, although the idea of false imprisonment is sometimes expressed in terms of a restriction on liberty which must be total, that does not mean that a restriction short of lock and key may not be actionable. In each case, it's a question of fact as to whether a restriction is so severe as to be characterised as false imprisonment. And that's where we see the example of an island where the only means of egress is by swimming through dangerous waters. There is no reasonable means of egress, and the victim's confinement to the island is likely to amount to false imprisonment. If, however, there is a reasonable means of egress or escape from detention, the restriction may not be enough. So, if a victim's confined to a room and there's a reasonable means of egress through a door, the victim is in effect free to leave the room and there is no false imprisonment. And we submit that is the correct principle, that it depends on whether there is or is not a reasonable means of egress. And that total doesn't mean absolutely total. Thirdly, where there is a reasonable means of egress, it appears to us that it does not matter that the victim may not make use of it. So long as there is a reasonable means of egress, there can be no imprisonment. Conversely, and this is very important, if the only means of egress is not reasonable, the false imprisonment will not come to an end unless and until the victim does make use of it. In short, so long as a victim remains confined without a reasonable means of escape, he or she will be falsely imprisoned. So, the RAF officer in a prisoner of war camp is imprisoned up to and until the moment that he exits the camp through his unreasonably constructed tunnel. Once he's
So
left,
you've got two elements, fact of confinement
yes,
and the circumstance that the constraints imposed are unreasonable.
that the only way you can leave,
The only way you can leave
is unreasonable.
is by having resort to an unreasonable.
Exactly. So if someone says, I'm leaving the door unlocked, but if you come out, I'm going to kill your child,
Yeah.
you're imprisoned. And if someone says...
Even if you do go out.
Even if you do go out. If someone says...
Until the point that you leave, you're imprisoned.
Yes. Until you leave, you're imprisoned. If you take that risk, you're no longer imprisoned, but you were imprisoned before. And similarly, in this case, if you say, I'm going to leave the door unlocked, but if you go out, you're liable to conviction on a fine of £5,000 and 6 months imprisonment, you're imprisoned until the moment you go out. Because it's not reasonable to say you can only leave your house by taking the risk of conviction. And it makes no difference to say, well, we might not prosecute you because we have a discretion as to prosecute, and you might be able to establish a defence of reasonable excuse. That's irrelevant. The point is, the Secretary of State had no business making that threat at all. The threat is a completely unreasonable threat. It means that the person cannot leave the house without taking an unreasonable risk.
And I think the further point that you would wish to make is that the lack of unreasonableness, if I can put it in that clumsy way, is not demonstrated by the circumstance that you have defied it.
Absolutely.
Yeah.
Absolutely.
I mean, that's something to be judged objectively, you say. Mm-hmm.
Yes. Yes, exactly. You could have two people subject to this restraining order, both of whom have family proceedings in Coventry, and one says, I will risk everything to have the chance of seeing my child, including the risk that I will go to jail, as this claimant did. And the other says, I'm so terrified of returning to immigration detention or returning to jail that I dare not go to Coventry, even if it means I won't see my child again. Doesn't matter. Both of those individuals are imprisoned. When one of them leaves, he's not imprisoned for the time that he's outside, but they're both imprisoned when they're submitting to the unreasonable conditions of the Secretary of State. So we say paragraph 43 here is very important and is a correct statement of the law. So fourthly, back to paragraph 44, and consequently, still on page 1881, where there is a reasonable means of egress, but the victim hesitates before making use of it, the period of hesitation will not count as a period of false imprisonment. So if you approach Hammersmith Bridge and you're stopped at the barrier, the fact that you have an argument for 10 minutes with the man before you turn around and go back doesn't mean you were falsely imprisoned for 10 minutes because you had a reasonable means of egress. Conversely, paragraph 45, we take the view that where there is not a reasonable means of egress and the victim hesitates before effecting an escape via an unreasonable means of escape, the period of hesitation would count as a period of false imprisonment. And that's the point that I've just been discussing with my Lord Kerr. We do not consider that an intentional tortfeasor should be heard to defend or plead in mitigation of a charge of false imprisonment that a more courageous victim may have escaped via an unreasonable means of escape, or so escape more quickly than the victim did in fact. So then they say, turning then to the notion of a police gate, if a victim's confined without physical means of egress, the victim may be able to call for police assistance. If the police answer the call and procure the victim's release, the imprisonment will come to an end. But obviously, the false imprisonment will have lasted until the release is effected. So it appears to us the ability to call police is not to be equated with a reasonable means of egress. Then they go to travel through the bush, which you see starts at 1882. And at page 1883, this is paragraph 54, that leaves the question whether egress through the bush gate was reasonable. The authorities reveal that there are 4 factors to be considered in determining whether a means of egress is reasonable. They are threat or danger to the self, threat or danger to property, including property of others, distance and time, and legality. And there is then a discussion of various authorities and different facts. And so, for example, if somebody is being is put against their will into a car, the fact that you could jump from a moving car is not a reasonable means of egress. Jumping out of a first-floor window is not a reasonable means of egress. But as the court will have seen, the 4th factor is legality. And legality, of course, was not directly an issue in this case. And what the court says is, paragraph 62, they say, the notion of illegality is in this context also variable. There is authority that egress may be reasonable, even if it requires a plaintiff to commit a minor trespass. And that is the citation of Wright and Wilson, on which my learned friend relies. To which we answer, absolutely. It may be reasonable to say you have a means of egress by committing a wholly technical minor trespass, but it's not reasonable to say you have a means of egress by risking prosecution for a criminal offence that could send you to jail. So we submit that the analysis in this case is in substance the analysis that the Court of Appeal adopted in our own case, and we submit it is correct.
Can I just check? I was just checking through. I think McFadzean was not cited to the Court of Appeal. That's why they don't deal with it.
Was it not? Was it not? Are you sure? Not at all.
Not one of the authorities listed as cited. I'm just wondering why they didn't deal with it. Sorry, it's not a criticism.
Yeah, no,
I just wanted to be factually clear that they.
I'm being told by Mr. Bunting that he only found it when we were doing the statement of case. Your Lordship's right.
Fine, yeah, it wasn't a criticism. I just wanted to check
correct.
I wasn't missing something.
But my Lord, of course, the analysis that the Court of Appeal adopt is in substance the same. And if we just go to the Court of Appeal judgment, you can see that. So this is back in the core bundle. The judgment starts at MS 150. And if we go to paragraph 82, page 168, they say, viewing matters overall, therefore, it's in truth inapposite to say that IJ had the ability to leave his house and that he could not physically be prevented from doing so, even if doing so involved unlawfulness. As indicated above, Wright and Wilson provides no adequate authoritative basis for so generalised an approach. The key here is reasonableness. In cases such as Bird and Jones and Robinson, the plaintiffs had reasonable and lawful alternative means of escape or of reaching their destination. Hence, there was no false imprisonment. In the present case, however, it cannot be adjudged to be reasonable that IJ could circumvent the curfew instruction by acting in a way which necessarily would attract a potential criminal sanction of a fine and or imprisonment. So that's the analysis in substance, which is the same as the analysis set out more fully in McFadzean. And as the Court of Appeal there indicate in our submission, that is in fact the underlying principle that explains the approach that was taken in Bird and the approach that was taken in Robinson. And in my submission, it can also be seen to be what underlies the decision in Phillips and the Great Northern Railway, the lady who was alleged to be no lady. That's at volume 1, tab 8, the altercation with the ticket inspector. And if the court goes to page MS 573, the key reasoning is towards the bottom of that page, about 10 lines up. On consideration, however, I think there was no evidence of imprisonment within the meaning of the authorities. There's no evidence that the plaintiff was so dominated by the action of the ticket collector that succumbing to that domination she lost her liberty. Her intended means of egress were interfered with, that of course is the cab, but she plainly could have left the station. And in the words of Mr. Justice Patterson, there was not a total restraint of the liberty of the person. So the point is that this individual, all that had happened was that the ticket inspector had said to her, stop, and had an argument with her. But she could have walked away, just because her cabbie was too feeble to get the horses to move.
The cab driver might have had a better case for
the cab driver. But that's why in my submission, it's not about the robustness of the individual. The cab driver could have walked away too. They both could have walked away, and there was nothing to prevent them. Now, what would make this case analogous to our own would be if the ticket inspector had given a piece of paper to the plaintiff in this case and said, this is an order under Section 1 of the Railways Act. I reasonably suspect you of having evaded your fare, and I exercise my power under this act to require you to remain at the station while I complete my investigation, and if you leave, you are liable on conviction to a fine of £5,000 and imprisonment for up to 6 months. That would be an analogy with this case, when in fact he had no authority to give her any such piece of paper at all. And in my submission, if those were the facts of this case, there would clearly have been a finding of false imprisonment. Because given that piece of paper, walking away would have been unreasonable. Now, there is also a case I want to show the court, a case of Walker and the Met Police Commissioner, which illustrates not only the distinction between false imprisonment and a loss of liberty under Article 5, but in my submission also the very wide ambit of the tort of false imprisonment. It's at Authorities Bundle 4, tab 51. And the MS number is 1696. Judgment of Lord Justice Reimer, Lord Justice Tomlinson and Sir Bernard Ricks. The judgment is actually by Sir Bernard Ricks, with whom the other two judges agree. There's a short judgment from Lord Justice Tomlinson as well. And as you can see from the head note, police officers have been called to a domestic dispute, and in the course of that dispute, one of the officers stood in the front doorway of the house in such a way as to prevent the claimant from leaving. It was a few seconds in which the claimant was prevented from leaving the house. And that was held to constitute false imprisonment. And if we go to paragraph 17, Sir Bernard Ricks discusses a case called Collins and Wilcock about a woman suspected of soliciting for the purposes of prostitution, who was accosted by a policewoman. And if we go on to paragraph 22, he cites Lord Justice Robert Gough in this case. He says, the word detaining can be used in more than one sense. It's a commonplace of ordinary life that one person may request another to stop and speak to him. If the latter complies with the request, he may be said to do so willingly or unwillingly. And in either event, the first person may be said to be stopping and detaining the latter. There's nothing unlawful in such an act. If a police officer so stops and detains another person, he's, in our opinion, he commits no unlawful act, despite the fact that his uniform may give his request a certain authority and so render it more likely to be complied with. So that's correctly the position that simply requesting or asking someone to stop and talk to you is not imprisonment. But, he goes on, if a police officer, not exercising his power of arrest, nevertheless reinforces his request with the actual use of force or with the threat, actual or implicit, to use force if the other person does not comply, then his act is thereby, in thereby detaining the other person, will be unlawful. So saying to a person, will you remain in your house, is not false imprisonment. But saying to the person, you must remain in your house, and if you leave, you will be liable to punishment, is false imprisonment, because the request is there backed up with the threat of force. And then again at paragraph 23, we see the same point at the end of that paragraph. The logic of the cases demonstrates if a police officer not exercising the power of arrest detains a person in a way that goes beyond the acceptable conduct of an ordinary member of the public, that will be false imprisonment, as where he uses the threat, actual or implied, to use force if the other person does not comply. He then cites Halsbury's on the definition of false imprisonment and refers to the Kettling case, and then at paragraph 26, the contrast with such a confinement is a mere obstruction, where a person is obstructed in only one direction but can pass in another, even if it's not the way they would choose to go. And there's then a reference to Burden-Jones, another indication that Burden-Jones is about direction. It's not authority for the proposition that there must be a complete restraint in the sense that a person is utterly powerless to resist. And then at 31, we see the point that there's no deprivation of liberty under Article 5. And Sir Bernard says that concept is not identical with the tort of false imprisonment. There may be a deprivation of liberty without false imprisonment and vice versa. And then Lord Justice Tomlinson at 46 says...
It's more likely that it would be false imprisonment without a deprivation of liberty under Article 5, isn't it, than vice versa?
It is, although, of course, the LL case in Strasbourg is an example of the latter, subject to the question of how LL will be decided if it came back to this court.
I understand that,
yes.
But I think that's the only...
Yes, but that's right, generally, and the Kettling case is a good example.
Yeah.
That Kettling is false imprisonment, but isn't...
Well, it's imprisonment.
Sorry, I beg your pardon, my lady. It's imprisonment.
But not false
Subject
because of the...
If it's justified.
Yeah.
Yes. It's imprisonment which may be justified. And that case, of course, illustrates one of the obvious reasons why it's not surprising that there are differences between false imprisonment and Article 5, because Article 5 is not a generally qualified right, which can be interfered with whenever it's proportionate. There's an exhaustive list of the lawful purposes for which there may be a deprivation of liberty under Article 5. And the reasoning of the European Court of Human Rights in Austin, the Kettling case, makes it clear that that was a key reason why the court was anxious to find that there was no deprivation of liberty in that case, because had there been a deprivation of liberty, it would perforce have been a breach of Article 5, because it didn't fall within any of the permissible purposes in Article 5. The common law tort of false imprisonment is more flexible in that once imprisonment has been shown, the defendant has a defence if they can show that there is a lawful justification. And what constitutes a lawful justification is not constrained by the kind of limits that apply in Article 5. So that's an obvious reason why there's a difference between the scope of the two torts, of the two rights. And if we then just very briefly go to paragraph 46, page 1714, Lord Justice Tomlinson, I agree. And he says this: Mr. Walker's conduct attracts no sympathy, but that is, of course, often the way when a fundamental constitutional principle is at stake. So there you see the appreciation of the Court of Appeal that you don't lightly erode the right to liberty at common law. So even if it's just a few seconds in a doorway, it's a tort. That then brings me to JJ. And my learned friend showed you JJ, which is, of course, the control orders case, and rightly points out that this is a case concerned with Article 5 and deprivation of liberty. It's not concerned with the tort of false imprisonment. But in my submission, there are some statements made by my lady in that case on facts which are strikingly similar to the facts of this case, which are of wider application than Article 5 alone. And my lady's speech begins at MS 696. Paragraph 57. And at paragraph 57, your ladyship poses the question, what does it mean to be deprived of one's liberty? And there sets out the essential test that's applied in Strasbourg. And then at 58, the Strasbourg jurisprudence does tell us that deprivation of liberty may take numerous other forms than classic detention in prison or strict arrest imposed on a serviceman. So your ladyship there is making the point that a deprivation of liberty may extend beyond classic detention in prison or classic confinement. And then at paragraph 59, your ladyship says this: the judge took as his starting point the requirement to remain in the residence for 18 hours each day between 4 p.m. and 10 a.m. This is classic detention or confinement. So the point with respect that your ladyship was making there is that this element of the control order is classic hardcore detention in the narrowest sense. It is secured by electronic tagging, a requirement to clock out on leaving and clock in on returning. I say in parenthesis, that requirement doesn't apply in this case. And by arrest and imprisonment for disobedience, rather than by lock and key. But that makes no difference. To determine whether a person is deprived of his or her liberty, the court must look on the actual circumstances of the regime to which he or she was subject as a matter of law and in fact. Having the opportunity to breach the requirements of that regime does not take it outside Article 5. Now, in my submission, all of the reasoning in that paragraph applies just as much to the definition of imprisonment at common law as it does to classic detention within the ambit of Article 5. And your ladyship there refers to a case called Pikov and Bulgaria. We have copies if the court would like to see it. What happened in that case was it was a case of a court order imposing house arrest. And the court was at a substantial distance away from the residence where the individual was placed under house arrest. And the Bulgarian government argued that that was not a deprivation of liberty because it couldn't be enforced. And the Strasbourg court said that makes no difference. The fact that the person had an opportunity to breach the order doesn't make any difference. He was deprived of his liberty because he couldn't leave his house without breaking the law. If I can just hand out copies of that case.
Thank you.
The relevant paragraph is paragraph 73. It's at page 12 of the printout. On the 2nd of October 1996, says the court, his deprivation of liberty took the form of house arrest, which lasted till the 3rd of July 2003. The court's already held that house arrest constitutes deprivation of liberty. It is furthermore unable to subscribe to the government's argument that the applicant's house arrest did not in fact amount to a custodial measure because the authorities responsible for monitoring compliance with it were far away, which allowed him to breach it with impunity. To determine whether a person is deprived of his or her liberty, the court must look on the actual circumstances of the regime to which he or she was subject as a matter of law and fact. In a case, and then there's reference to persons of unsound mind and persons infected by HIV. And then at the bottom, by the same token, in the instant case, the fact the applicant had the opportunity to breach his house arrest cannot lead to the conclusion that it did not fall in the ambit of Article 5. Now, your ladyship, after that paragraph 59, then goes on at paragraph 60, so that's at MS 697, to conduct the more holistic assessment of the regime as a whole, which Article 5 requires. Because the key difference in this respect between Article 5 and imprisonment at common law is, as we've seen in Walker, depriving somebody of their liberty even for a few seconds constitutes imprisonment at common law. But under Article 5, a different approach is taken, and the court will look holistically at the restrictions placed on a person, and even if for parts of the day they're confined to a particular place, won't necessarily conclude that there's a deprivation of liberty if on other parts of the day they're free to move around. And that's the assessment that is then conducted. And at 61, your ladyship said, undoubtedly, these people were deprived of their liberty during the curfew hours. Did the fact they were allowed out for up to 6 hours a day make any difference? And then conducts that assessment. Lord Hoffman, at paragraph 42, he dissented in the result. But it's at page 692. But he makes the point at 42, it's clear that the absence of certain features of the standard case of imprisonment, for example, locked doors or institutional surroundings, are not essential to the concept of deprivation of liberty. One may be deprived of liberty by being placed in an open prison where the doors are not locked, but one will be punished if one leaves without permission. Or one may be imprisoned under house arrest in one's own home. And he also cites Peikoff. Bear in mind that it is the necessary implication of my learned friend's submission that a curfew, a 24-hour curfew amounting to total house arrest, would not be imprisonment for the purposes of the tort of false imprisonment. That the Secretary of State could confine somebody to their home on pain of criminal prosecution, effectively in solitary confinement 24 hours a day, without that engaging the tort of false imprisonment. That is his case. Finally, a case of Rumble, which is in Authorities Bundle 4, tab 46. This is a case of a man who was on trial in the magistrate's court. He'd been, MS 1574.
Thank you.
He was on trial in the magistrate's court. He'd been on bail, and he surrendered to the court was tried and was given a custodial sentence. But there were no security officers in the court and not even an usher. And so he simply walked out at the end of the hearing. And the question was whether he had escaped from lawful custody. And that depended on whether he was ever in lawful custody. And he argued that he wasn't in lawful custody because there was never anybody there who was capable of controlling him. And if we go to page 1576, paragraph 4, you can see in the middle of that paragraph said if for a person to be in custody, his liberty must be subject to such constraint or restriction that he can be said to be confined by another in the sense that his immediate freedom of movement is under the direct control of another. And the argument there was that he wasn't under anybody's direct control. And at paragraph 5, that argument has only to be stated for it to be seen it would be extremely odd if it were correct. Once a person surrenders at the court, as Mr. Rumble did, and was obliged by law to do, it would be very surprising indeed if the court's right to control him and his vulnerability to the offence of escaping depended on the precise nature of the physical constraints imposed on him. And then at paragraph 6, when Mr. Justice Forbes spoke of direct control, he was not conceivably seeking to impose different rules according to the physical constraints placed on a person when already in custody under the Bail Act. It's sufficient if, as a matter of law, the person is under constraint. And that, we say again, is analogous here. If, as a matter of law, the person is told it's unlawful for you to leave, or you're at risk of prosecution if you leave, then they are being detained. And that's the reason why both this curfew and false imprisonment constitute, imprisonment in an open prison constitute imprisonment. In an open prison, there are no locks or bars. The person may go out to work every day in the community, but they are still imprisoned. And the reasons for that are not the reasons that my learned friend has given. He has sought, with great respect, to make specious distinctions between imprisonment in an open prison and a curfew of this type. He makes the point that in relation to an open prison, the warrant could entitle the person to be imprisoned in a high security prison or any type of prison, to which the answer is, so what? If he was in fact in an open prison, it doesn't matter that there would have been a right to confine him in a more secure way. He also makes the point that if the person were to abscond from the open prison, they would be unlawfully at large and could be returned to the open prison. Again, we say, so what? It doesn't matter whether the consequence of your escape is that you can be returned directly to the custody or you can be subject to arrest and punishment. The reason you're confined is not because of the precise nature of the sanction that will be imposed on you if escaped. It's because of the threat that if you do leave, you will be punished. It doesn't matter whether the punishment is being returned to your house or being fined and imprisoned.
Your analogy with open prison goes to the first argument, that is the fact of imprisonment,
Yes.
not to the question of the lack of reasonableness of the conditions of restraint.
That's right.
So
That you're imprisoned in an open prison, even though there's no lock, there's no guard, and you can walk out the door. But if you do walk out of the door in a way not permitted by your license, you'll be committing a criminal offence. And that's why you're imprisoned in an open prison. Because you are, in fact, confined to that fixed boundary. So we submit that those are the relevant authorities that substantiate the legal analysis that I presented just after the short adjournment. And in my submission, when you apply the principles of law to the facts of this case, there's no doubt that there was imprisonment in this case. Mr. Jalloh was told by the Secretary of State that a restriction was being imposed on him under law, that he was required to remain within an identified boundary between specified hours, that his compliance was being monitored by a tag, and that if he breached the restriction, he was liable on conviction to punishment. That constituted the type of instruction referred to in Walker, an instruction backed by a coercive threat of force. It resulted in the total restraint of his liberty in the sense that he was required to stay within the defined boundary, and he could only leave by unreasonable means or taking an unreasonable risk, the risk of criminal prosecution. In those circumstances, there is imprisonment, in this case, of course, false imprisonment, because there's no reasonable justification. There is no additional requirement on those facts that he must demonstrate on the facts that his will was totally overborne. That's the facts I've identified as sufficient. As a matter of fact, the court has seen on the evidence that it is a travesty for my learned friend to suggest that he was only there when he chose to be and that he left when he chose to be. The evidence which was accepted by Mr. Justice Lewis is that he was indeed very afraid of the consequences if he left, that he endeavoured to comply with the curfew, and that the circumstances in which he defied the threat of punishment were specifically when he sought to attend the family proceedings or religious observance. And in the language of the Australian case, the fact that there were occasions when he took an unreasonable risk and left the property by unreasonable means didn't mean that he wasn't imprisoned when he was there during curfew hours.
Do you invite us to adopt that part of the test in the McFadden case that suggests that it is incumbent upon the complainant to prove that but for the constraint he would have left? It's not as high a test, I think, as showing that his will was totally overborne.
Yes.
But it does involve an element of causation.
My Lord, in my submission, it would depend on the particular nature of the constraint. And you can see why, on the case before them, that was a particular issue, because it was simply one set of individuals setting up a blockade against another set of individuals. But in my submission, where you have a person who is being told by the state, you must remain here or you'll be subject to prosecution, then there's a powerful presumption that that's why they're staying there. It would be pretty difficult to displace that. Now, I suppose you might get an extreme case where, if you took, for example, my learned friend's case of the prankster, going down the road saying, I'm a police officer and I'm instructing you to stay indoors and it's a criminal offence if you leave. And if the evidence is that nobody believed for a minute that this was credible and thought it was nonsense, then you would say, well, there's no false imprisonment because nobody took any notice of it. But that's obviously very different from this situation where you've got the Secretary of State with the full panoply of the state behind her, ordering him to stay in his house on pain of criminal prosecution.
I understood on your submission that you supported Lord Justice Atkin's analysis in the Meering case, where he talks about people being asleep and so on. So, so that would be a situation.
Yes, it would.
Satisfied but for.
It would, my Lord. Yeah, it would, my Lord. And another, of course, is a person who's under sedation, as in the LL case, who's not capable of understanding that they're constrained. So essentially, we do say that it's a test that can be satisfied by looking at the facts of the nature of the constraint that's imposed and whether there's a reasonable method of leaving. Now then, we submit that the Court of Appeal's judgment in this case is entirely correct. That is MS 150. And in particular, the relevant analysis in our submission, in particular paragraphs 64 to 68 at page MS 166 and 71 to 82 starting on page 167 and going down to 168. Again, I don't propose to read that out, but I invite the court to read it, and in our submission it is correct. And in summary, the key finding is that Mr. Jalloh was confined to the flat during curfew hours by threat of punishment if he left. There was no reasonable means by which he could escape. It wasn't reasonable for him to take the risk of prosecution. That, we say, is sufficient for the dismissing of this appeal, and it will be apparent from this what we identify as the flaws in the Secretary of State's case. Essentially, we say that the Secretary of State entirely mischaracterizes the facts of this case to suggest that Mr. Jalloh had a choice or that he simply chose to remain indoors. That is a very curious way of putting the facts when a citizen is told by the state, if you leave this place, you're liable to prosecution. The way that the Secretary of State's case was put in the written case was that there must be means to physically prevent the individual from leaving. You can see that at paragraph 4.11 of the written case. That's obviously wrong, and I'm not sure that it was even maintained orally. There is then the central point that my learned friend makes, which is his argument that the constraint must be total or complete. And the way he puts it is, the ability to leave by some route means there is no imprisonment. And the court will know that we say that is a misstatement of the law. It must be the ability to leave by some reasonable route.
I think we know what you object to in the appellant's case.
Yes, I think that's right, my lady. I'm just checking that I haven't missed anything. Yes, and the key point about the fifth, of course, is that my learned friend equates a technical trespass with criminal prosecution, and we say again that is wrong. Now, he relied then on some hypothetical examples, which are at MS 94. The first is the mere instruction given by the department store employee to a shopper to stay where they are. And he says, if they're physically free to ignore the instruction, not physically constrained, then that wouldn't be imprisonment. We say that's completely the wrong approach. It's not a question of physical constraint. If the store detective said, you mustn't leave here, and if you do, you'll be liable to criminal prosecution, then that would be false imprisonment. The second is a mere instruction to remain on the floor because of an incident below. Again, no threat. So the lack of any threat here is the key element that's lacking from a learned friend's analysis, and I've already dealt with the prankster. In his oral submissions, my learned friend added another one, which is to refer to the reporting requirement here, the requirement on Mr. Jalloh to report between particular hours. And he said, oh, well, if the curfew is imprisonment, then so is the reporting requirement, because it requires him to go to a particular place. The obvious difference is that it doesn't require him to go to a particular place at a particular time. It gives him a window within which he is required to go. Now, whether that does or doesn't constitute imprisonment is a matter that's not before this court. Of course, there are circumstances where if a warrant is issued requiring a person to surrender to the police or surrender to a court, that would be imprisonment. But that's not the same thing as a reporting requirement giving you a window.
Anyway,
in any event, it's lawful.
Yes, right.
So
That would be lawful justification, even if you got into it.
That's right. That's right. But whether it would or wouldn't be imprisonment, who can say? The court, your lordships and your ladyship have before you the MS case, which was shown to you, where there's a difference between a curfew of this nature that says you must stay indoors every night and a curfew that says you must be at home for 10 days in a month. Finally, to deal with Article 5, the point has hardly been pursued with any great enthusiasm by my learned friend, and we submit rightly so, because it is hopelessly flawed. We have dealt with Article 5 in our written case. It starts at paragraph 47 on page MS 135. And we make the point that it is trite law that you don't reduce the protection of common law rights in order for them to comply with the Convention. The Convention sets a minimum floor for fundamental rights protection. It cannot be used to reduce the protection given by the common law to fundamental rights. There are many examples of this. One example is Al-Rawi, dealing with the right to know the case against you. And at common law, that is an absolute right. Under Article 6, it is not an absolute right. And we've already considered some of the obvious reasons why there might be a distinction between a deprivation of liberty and false imprisonment at common law, particularly the difference in terms of the defences to such a claim. There are also, of course, controversial questions about the quality of the ECHR's case law, particularly in relation to kettling, but these are not matters that this court needs to get into. In my submission, there is simply no basis for altering the scope of the established principles of common law protection by reference to the European Convention on Human Rights. Unless I can be of any further assistance, those are the submissions for the respondent.
No, thank you, Ms. Rose. Mr. Bunty?
Please, Court. Just a reasonably small number of points to to make in reply. First of all, on an administrative matter, I was reminded that I'd forgotten to mention that in the additional bundle at tab 6, there is, I don't think I really need to ask to turn it up now, there is a replacement for the paragraph of Clark and Linsell, which has always been central to the way in which the case has been argued. The reason is that the first supplement to the current edition replaced the paragraph in its entirety. Amongst other things, it cited the Court of Appeal's judgment in this case. So that is where it now is. I'm sorry that that has had to go into the additional materials. The next thing to deal with is the suggestion that we have somehow, in referring to the facts of Mr. Jalloh's own case, changed the way that the case has been argued from that which was before Mr. Justice Lewis. It's right, I think, to say that when the point was before the courts in Geddy, it was much more abstract, but it certainly wasn't abstract as far as Mr. Justice Lewis was concerned. If I can ask you please to turn to Appendix 2 at page 168, which is MS 315. You'll see there the amended detailed grounds of defence. So the detailed grounds of defence had been done before the first hearing, and these were amended immediately after the first hearing. And the relevant part is what you can find on page 180, MS 327, which was in the original version of the grounds. And there at 5.11 is set out the features of the curfew imposed on the respondent, and in familiar terms as to what was their what was the nature of the curfew, including in the footnote the fact that the claimant was not completely compliant. That was then amplified in the skeleton argument for the first hearing, which you have in Appendix 2 at page 202. This is MS 349. And if you go on within that to MS 357, so page 210, MS 357, you'll see that at paragraph 311, substantially the same text as there in this skeleton argument, but the footnote there is then amplified at the bottom of the next page, bottom of MS 358, recording a three-digit number of occasions on which the claimant was absent from home for more than 15 minutes. It would include those absences authorised in advance as well as those not authorised, and it mentions that he was sent warning letters in relation to 34 unauthorised breaches. And so it is in that context that when Mr. Justice Lewis gave his first judgment, he referred to this in general terms, but without making specific findings of fact about it. Appendix page 30, MS 177, at paragraph 14, he said, there are occasions when it appears claimant did not in fact spend the hours from 2300 to 0700 at the premises. There appear to be days when he arrived after 2300 or left before 0700. There were occasions when the claimant did not stay at the premises without any variation of the condition. Neither the claimant nor the defendant was in a position to invite the court to find as a fact. So that the structure of the facts was there, even though Mr. Justice Lewis wasn't being asked to make findings of fact. And if you go on to MS 186, paragraph 42, there's a further reference to the nature of the case. In the middle of that paragraph, relating my submissions, that there was no physical impediment to the claimant leaving the property, and in fact he appears to have been absent from the property during the specified time on a number of occasions. So that was the background, the context to Mr. Justice Lewis's first judgment, and it's not right to say that we have completely changed the way that we put our case. What you can see from the facts is what is now the established detail.
Yes, but I mean, as I understood it, and I was party to give a permission, that we were being asked to decide this case here because it raised a general point of public importance.
Certainly, it is
to this particular gentleman's and the facts of his case.
Well, look, certainly it is a point of general public importance because the same will apply to many of these cases.
Yes, but regardless of how a particular person happens to react to the particular...
Indeed, and it may be that this court's decision will indicate the circumstances in which an individual is or is not to be regarded as having been imprisoned when he's under a curfew such as this. This claimant's case gives a particular context and spread of facts that has always been part of these judgments throughout. And the number of cases that this could affect makes it of importance because where the dividing line is drawn, and these aren't easy lines to draw, as we can see from the authorities, may affect the way that other cases are dealt with. And that's
just coming back to the point I made earlier on, I am concerned we seem to have no information about the policy, the enforcement policy. I mean, the inference one would draw from what we know is that on his evidence, he only left because he had what he would regard as a reasonable excuse, either Ramadan or his proceedings. And we must assume, mustn't we, that those enforcing took a similar view, and that was the reason he wasn't prosecuted. As if there had been something which they regarded as a serious breach, they would presumably have done something about it.
Well, as I said, I can't give specific answers. I can see the force of the suggestion that if he was non-compliant because of Ramadan or non-compliant because of the family court proceedings, he might have had a stronger case to have had a reasonable excuse. I don't think I can pretend otherwise. But those weren't the only reasons why he...
No, but why can't we infer from the fact that he never was prosecuted, no one ever did do anything about it, that those in charge were satisfied that what he was doing was a good.
There were a number of occasions on which he advanced no reason or excuse or explanation at all for his absence. You have his witness statement in Appendix 2, and that sets out in quite a lot of detail, put together with the aid of solicitors, I think it was. It must have been given the form. And there are a large number of occasions when there was no proffered excuse or
I
explanation.
know, but from your point of view, we still face the fact we have no statement of what the enforcement policy was,
Yes.
whether there was any enforcement policy.
That is because the question of whether he was imprisoned or not is really one which is to which the question of the reasonableness of his excuse is irrelevant. It's looking at
Yeah, well, there we are.
the quality of the constraint. It is to the quality of the constraint that I turn next, because my learned friend puts a great deal of store by the Australian case of McFadgen. This is Authorities 4 tab 57, MS 1866. While I can see that this case would provide some support for the proposition that if the defendant relies on the availability of egress as a reason why there was no imprisonment, then that egress must not be an unreasonable one. But what my learned friend has not addressed is the more fundamental analysis made in this case, which is still the requirement for submission to the will of the defendant. And you see this in a number of places. Can I start at MS 1876 in paragraph 31? The third sentence, the conduct with which the law is concerned must be of a coercive character and amount to a total restraint. So this is the same sort of language as we see from the British authorities. The question of whether a defendant's conduct has influenced the plaintiff's action not necessarily determine whether the plaintiff has been detained against his or her will. In some circumstances, false imprisonment may be made out even though the conduct of the defendant has not had any influence upon the plaintiff's course of action. Neither is converse always the case. The fact that the defendant's conduct may have influenced the plaintiff will not always lead to the conclusion that there has been an involuntary submission by the plaintiff to the defendant's restraint. So there is a very basic concept, the concept of submission. Going over the page to paragraph 35, two-thirds of the way through that paragraph, where there is no application of force, and that is, of course, our kind of case, there must be evidence of complete submission by the person alleging imprisonment to the control of the other party. And then paragraph... Sorry. Thus, as Chief Justice Murray said in Symes and Mahon, there will be no false imprisonment if there is only partial obstruction of the will, whatever inconvenience it may bring if the means of escape is available. I think that's language that probably originates in Bird and Jones. And then going over to 41, halfway through the paragraph, it is not sufficient in law that the conduct of the defendant have contributed to or influenced the plaintiff's decision to remain unless the conduct has overborne the plaintiff's will. And so this is a basic proposition, after which the court goes on to discuss egress and whether that is reasonable or unreasonable. And so we adhere to the submission that there must be a total constraint by the domination of will that is required by the authorities. My learned friend also suggested that there was an objective test to this, but so far as the domination of will is concerned, the authorities are clear that it's a subjective test. I'm not going to turn up authorities I've already turned up, but can I mention Bird and Jones itself? This is Authorities 1 tab 3. It starts at MS 487, but at MS 489, Mr. Justice Williams refers to the plaintiff if the plaintiff feels he has no option. And also at 489, an entire restraint upon the will. and Mr. Justice Patterson at MS 491 referring to obstruction of his will. And all of that is language of a subjective nature, not looking purely at the objective reasonableness of egress. As far as my learned friend's point about the language in Burden-Jones of total restraint is concerned, it doesn't relate only to direction, or it's certainly not the way it was understood in Phillips, the Irish Railway case. Can I ask to turn that up quickly? It's Authorities 1 tab 8 MS 572. And if you go on, in fact, 573, the very bottom right-hand corner, about 6 lines, sorry, about 10 lines up, the passage that my learned friend referred to about being no evidence the plaintiff was so dominated by the action of the ticket collector that succumbing to that domination she lost her liberty. That's not to do with direction, that's to do with entirely submitting to the will of the ticket collector who said, stay there. And it's in that context that the court then cites Burden-Jones about there not being a total restraint of the liberty of the person. So total restraint clearly includes the concept of total submission to the will of another. It is not just to do with direction. Learned friend seeks to criticise Ex parte L on the basis that Lord Gough got confused between necessity and imprisonment. With respect, he did no such thing. The problem is that there were two concepts that were, two periods conceptually that were being referred to here. Ex parte L is Authorities 1 tab 11. Can I go straight to MS 641? It's page 489 of the report. Halfway between A and B, he refers first of all to times when it might be said that L was detained in the sense that in the absence of justification, false imprisonment would have been committed, had in mind the journey by ambulance from the day centre to the A&E unit, but that journey was plainly justified by necessity. So that was one period conceptually, including the journey by ambulance, clearly detained, but necessary. And then halfway between letters D and E, he then goes on to the second period conceptually, which is being admitted to hospital in those circumstances, sedated, could have left, but if he had left, he would have immediately been sectioned and put straight back there. And that is where the House was divided, 3-2, with the majority saying that there was no detention, even though there would have been a section immediately after that. So there was no confusion there, and that case remains good law. If you go back to page 638, you'll see all these key authorities being cited. There's Meering, there's Yusuf Uddin, and these are the foundation of that, and there's really no reason to suppose that the court today would necessarily find differently. Obviously, with 3-2 split in their lordship's house, you'd never know quite what would happen if it was rerun today, but it's not a foregone conclusion, which I think is what learned friend was implicitly trying to suggest. The learned friend relies on JJ and some dicta which she said supported the notion that the curfew was a deprivation of liberty. We would point out that if you, JJ is Authorities 1 tab 13. I don't need to turn it up now, but what I would draw attention to is the lists of cases cited in the judgments and cited in argument. And there's a very long list of cases cited in argument at MS 659 to 663. As far as I can see, they don't include any of the false imprisonment cases that are in our primary volume. And that's for the obvious reason that it was really not a false imprisonment case at all, and these concepts were never argued. And we respectfully say that whatever first impression dicta might have fallen from the House in that case, it's not authoritative about whether or not imprisonment was made out. And the language that's used, including the paragraph from Lord Hoffman's speech referred to, is all about deprivation of liberty, because the case was talking about the Article 5 concept. Rumble, the man who escaped from court, learned friend says it's like the open prison, and we actually respectfully agree with that, because just like the Prisons Act case, the result in Rumble depends on the legal position that when you answer to bail in a criminal court, you surrender yourself, you legally surrender yourself to the court's custody. It may be, in practical terms, a bit of a fiction, because many courts don't have much security, but that is the legal position. And that is why the case was decided in the way that it did. Decided in the way that it was. If you try and directly apply that to the respondent's case, you're actually just begging the very question that's in issue here. In Rumble and in an open prison, you're not in custody merely because you might be prosecuted if you escape. You're in custody because the law says that when you surrender to a court, you're in custody. In an open prison, you're in custody because the warrant says you're in prison and the Prison Act says you're in prison. And that's the difference, and it is a very real difference. Finally, the point that learned friend makes about the backing of a threat of force if you don't comply. For that, she cited Walker in the Court of Appeal, which itself cited extensively from Collins and Wilcock. I don't think it's been mentioned. Collins and Wilcock is in Authorities 3, tab 32 at MS 1140. I don't need to turn that up now, but I just need to say that just because there's a threat of force, we know from the authorities that it does not follow that imprisonment is involved. Because from Arrowsmith, which is good law, from Berry, from the Canadian Ferguson and Jensen, that trio of cases alone shows that even if you've got a warrant that could be executed straight away, and you can be taken straight into custody by executing the warrant, it doesn't mean that the person who's complying with the request is imprisoned. And so there's a complete non sequitur there. So for all those reasons, we adhere to the submission that the respondent, in the circumstances in which he was, in the way that he treated this curfew, and his ability, undoubted ability, if he chose to not comply and to leave, meant that he was not imprisoned. He was not totally restrained. His will was not overborne. He was not submitting to that in the way that the law requires. It is a case that falls on the line of not being imprisoned, and we invite the court so to hold and to reverse the Court of Appeal's decision. Unless I can assist any further.
It appears not, Mr. Tam. Thank you very much indeed, and congratulations on the excellent timing all round. Thank you to everybody for their very helpful submissions in this case. Well, as Mr. Tam said, we are fully aware, of course, of the assistance that the leaders who are on their feet get from those who sit beside or behind them, and we acknowledge that assistance to the court as well. And we will now go away and try and work out what the answer is, and let you know in the usual way. Thank you. The court will now adjourn.